So we are thrilled to welcome Professor Franita Tolson, who will be talking to us about elections and race. So Professor Tolson is one of our very own alums. As I mentioned earlier, we are lucky to have her back visiting with us this spring, where she'll be teaching election law. I hope all of you enroll. It should be terrific. And she's currently the Vice Dean for Faculty and Academic Affairs and Professor of Law at the University of Southern California Gould School of Law. Before entering academia, she clerked on our very own Seventh Circuit for the Honorable Judge Williams, and also the Honorable Ruben Castillo of the Northern District of Illinois. Not surprisingly, given the reason that she's with us, she's been teaching focus on the area of election law, constitutional law, legal history, and employment discrimination. She's written on a wide range of topics, spanning from partisan gerrymandering, political parties, the elections clause, basically everything that we're talking about these days, and especially in these days leading up to the election. And indeed, you've probably seen her all over the media. She's a legal analyst for CNN, and she also co-hosts a podcast that is really, really fantastic called Free and Fair with Fernita and Foley. So with that, I will turn it over to Professor Tolson to talk to us about elections and race.
All right, thank you so much, Professor No. It's very, I always feel a little weird coming back to Chicago. I gave a workshop maybe a year and a half ago, and I remember being so nervous because a lot of my former professors were in the room. So it was very weird for me, but it is such a treat to be able to come back and talk about the things that motivate me both in my writing and my teaching. So of course, we're in the middle of an election season, and if you guys have followed the news reports at all, we're in the midst of a election season in which turnout will probably be historic. There are counties in Texas that have already surpassed their 2016 turnout numbers. And so it's also a moment for us to reflect on what we want our democracy to look like. Who knows what will happen a week from now, but just in terms of things that have happened so far, it really is an opportunity for introspection of sorts. For me, I think part of the reason why there's so much excitement and interest in the upcoming election is because American democracy is at a crossroads, right? Voter suppression in particular is on the rise precisely because it is a necessary tool to ensure the continued dominance of a political minority in this country. Yet voter suppression, voter disenfranchisement, and minority rule, if left unchecked, will be the very thing that destroys our system of government. And this remains true even if we get to next week and we know who the president will be. We still have to revisit these particular flaws in our system. One of the things I want to talk to you about today is sort of putting the current moment in historical perspective, and then I want to talk about how it ties into my book project that I'm currently working on and will be out next year. So when we think about voter suppression more generally, it's important to understand that it's contextual. And many of the laws that we take for granted can be suppressive, depending on the context. For example, voter registration was once a suppression technique, even though it's now accepted as a necessary precondition to becoming a qualified voter. What it tells us is that even legal restrictions can be suppressive to some extent. And in fact, it is the legal restrictions that elected officials are most trying to exploit, and that the courts have done little to protect the right to vote in these circumstances. So just to give you a few examples, just in the last couple of weeks, the Sixth Circuit restored a Michigan ban on providing free transportation for people to get to the polls. Also recently, Seventh Circuit, the court upheld an Indiana law permitting those over 65 to vote by mail, while denying the same privilege to those under 65 who need an excuse to vote by mail. The 11th Circuit, in a recent decision, made it difficult for those with felony convictions to vote by requiring payment of all fines and fees prior to casting a ballot, which seemed to undermine the spirit of a recent ballot initiative that re-enfranchised this population. And of course, there was a Supreme Court decision about the Alabama law, which prevented curbside voting. Curbside voting would have helped elderly voters and voters with disability more easily cast a ballot. So many of the restrictions upheld by courts are either reinforcing historical disenfranchisement techniques like felon disenfranchisement, or mimicking historical efforts to disenfranchise by raising the cost of participation. COVID-19 in particular has exacerbated this situation. We saw many of these restrictions bear fruit in recent primaries where voters waited 4 or 5 and sometimes 6 hours in line to vote in the middle of the pandemic. So examples include Wisconsin, which resulted in a Supreme Court decision, RNC versus DNC, that made it difficult for individuals to have their absentee ballots cast. And then Georgia, which has been in the news both during the primary season and now because of the really, really long line. So some voters waited up to 11 hours to cast a ballot during the in-person early voting period. Right now, there are at least 200 COVID voting related suits in more than 40 states. So the litigation is definitely plentiful. The problem though is that the right to vote is losing. Right, so the right to vote is losing, despite the fact that many of our current practices have their basis in laws enacted by states in the late 19th century for the express purpose of disenfranchising African Americans, poor whites, and also suppressing the vote. Most of these suppression efforts did not technically violate the US Constitution, at least as that document was then interpreted. In fact, the adoption of discriminatory state constitutions in the 1890s was mostly race neutral. Right, so states were able to circumscribe the electorate by making changes to their state constitutions in ways that did not explicitly mention race. So to give you an example of this, Mississippi was pretty relentless in its quest to disenfranchise African Americans and also eliminate any prospect of federal oversight of its elections. In 1890, the state was the first to call a constitutional convention to amend the Constitution and change its voter qualification standards to make it more difficult to vote. The state constitution introduced a very onerous residency rule. It required that voters live in the state for 2 years and be registered 4 months before the next election. And of course, that sounds crazy, especially if you compare it to complaints about having to wait 30 days, which is a requirement that some states have now. In Mississippi in 1890, it was 4 months. The Mississippi Constitution also imposed a literacy test. It required potential voters to read a provision of the state constitution. And this was at a time when individuals were, when literacy was not as widespread as it is now. The state also instituted a poll tax of $2. This tax was successful in disenfranchising African Americans in most of Mississippi's counties. Historically, a poll tax was a tax paid as a precondition to voting. And in fact, it was one of the most effective barriers to voting ever devised. Right, $2 may not sound like a lot, but in 1880, the average Southerner only made $86 a year. In 1900, it was $100 a year. So having to pay a $2 poll tax was pretty significant. Mississippi, for its part, served as a model, right, for the rest of the South, for the rest of the former Confederacy that was also looking to disenfranchise African Americans and some poor whites who aligned themselves with African Americans politically. The Mississippi Constitution cut African American turnout from 30% in the 1888 presidential race to virtually nothing thereafter. Importantly, and one thing I want to continue to emphasize is that it wasn't that these laws were obviously illegal, right? They did not expressly say we do not want African Americans to vote, although many legislators in adopting these race neutral policies articulated that intention. So the 1960s were particularly important because it was one of the first times where you had a concerted effort to eradicate many of these practices. But the end result was that these efforts to suppress just merely evolved. They did not completely disappear. In particular, the poll tax, as I mentioned prior, is now illegal because of Supreme Court case law and constitutional amendment. But it was a way to exploit wealth distinctions and systemic inequality, and it disproportionately affected people of color. If you look at voter ID laws, proof of citizenship requirements, and felon disenfranchisement, as well as conditions imposed on felon reenfranchisement that I mentioned in the context of the 11th Circuit case, these laws also replicate these inequalities, even though these laws remain legal. This attack on voting rights and the judiciary's refusal to do anything about it really does stand as the most obvious indicator that our democracy is failing. Underlying the court's abdication of their duties is this belief that our elections and our institutions will continue to survive even if we exclude those who these institutions are supposed to serve. However, the survival of America requires us to understand that America is not inevitable. It's actually aspirational, and it's something that we have to continue to fight for, at least to the extent that we plan to continue to hold ourselves out as a democracy. So how do we fix it, right? How do we get at some of these problems in our political system? Well, we found ourselves here in part because of the Supreme Court's decision in Shelby County versus Holder. It's not that I'm saying that efforts to disenfranchise and suppress are new, But Shelby County really did open up the door for a new wave of disenfranchisement and suppression efforts. In Shelby County versus Holder, the Supreme Court invalidated a portion of the Voting Rights Act of 1965. In particular, the coverage formula, which would have required certain jurisdictions, mostly in the Deep South, but also parts of other jurisdictions, to pre-clear any changes to their voting laws with the federal government before those changes could go into effect. And the Supreme Court invalidated this provision on the ground that the coverage formula was based on outdated practices. So it had last been updated in the early 1970s, and the Supreme Court found that this was insufficient to justify the intrusion on state sovereignty, right? So essentially you had the states asking Big Brother to implement laws that they otherwise would have had the power to implement. So the end result, though, is that the Shelby County decision was essentially a green light for many Southern jurisdictions to be more repressive in their voting practices. The NAACP Legal Defense Fund recently released a report that details post-Shelby threats to the right to vote at both the state and local level. So, for example, the report documents how the day after the Shelby County decision, Alabama announced that it would enforce its restrictive photo ID law for the 2014 election cycle. Mississippi, Texas, North Carolina, all states followed Alabama and took advantage of the fact that they no longer had to pre-clear any changes to their laws with the federal government. Since Shelby County, hundreds of polling places have closed, making voting less accessible for people across a number of demographics. We're really seeing that bear fruit in the recent election with the long lines, right? So since Shelby County, Arizona has 212 fewer polling places. Louisiana has 103 fewer polling places. Mississippi has 44 fewer polling places. According to the NAACP, since 2013, jurisdictions formerly covered by the Voting Rights Act closed on average 20% more polling places per capita than jurisdictions in the rest of the country. Additionally, and also not surprisingly, many of these polling place closures are disproportionately in predominantly minority areas, compounding the difficulties for people of color trying to vote. The problem, too, with the Shelby County decision, and really where my work hopefully sheds light, is that the decision effectively limits Congress to addressing only the most overt and discriminatory instances of racial discrimination in voting. So much of this goes unchecked. So that's where I hope that my scholarship can make an intervention of sorts. So I'm currently working on a book project that I hope will clarify the scope of congressional power over voting elections, and by implication, the appropriate standard of review that the court should use to resolve the constitutionality of federal voting rights legislation. In some ways, the project is a response to Shelby, but hopefully it's much broader than that. Courts and commentators have assumed that the states are supreme in election regulation. And mostly you see this with the federalism arguments that crop up in the case law and in the scholarship. But my book argues that this is because we have misunderstood the full scope of Congress's power. Congressional power in this area does not derive solely from the 14th and 15th Amendments, which have received outsized attention because we disproportionately focus on the judicial enforcement of rights under these provisions. In particular, you'll see a lot of case law about Section 1 and Section 5 of the 14th Amendment, Section 1 and Section 2 of the 15th, but rarely do you see much discussion of the provisions in between, right, or the other provisions outside of the Reconstruction Amendments. So my book argues and really tries to fix this narrative by showing that Congress's power to regulate voting and elections derives from both structural provisions that serve as express delegations of power to Congress rather than the courts or the states. And in the book, I refer to this as the Constitution of Political Structure. And this is coupled with the individual rights provisions governing the right to vote that empower Congress to enforce their terms through appropriate legislation, which I refer to as the Constitution of Political Rights, right? So the provisions that we're used to talking about under the 14th and 15th Amendments. In particular, the book argues that through the Constitution of Political Structure, Congress had broad authority to regulate voting and elections prior to the Civil War, authority that was, importantly, unconstrained by federalism concerns, and authority that substantially increased with the ratification of the Reconstruction Amendments. The Reconstruction Amendments expanded the constitutional political structure and altered the constitutional political rights, shifting significant authority to protect voting rights from the states to Congress, and in the process, according the right to vote independent federal significance, which was separate from its state law origins. Prior to Reconstruction, the right to vote was largely regulated by state law. After the ratification of the Reconstruction Amendments, you see a shift from the states to the federal government over the core right to vote enshrined in state constitutions. Importantly, focusing on sort of this evolution of congressional parties' power. So I start at the founding and I take it all the way through the Reconstruction era, stopping just short of the Jim Crow era. It reveals a larger story about the creation and death of political norms. And more pointedly, the role of politics and partisanship in shaping the boundaries of federal power over election. So Congress had broad authority to regulate pursuant to the constitution of political structure prior to the war, as I mentioned, but political norms dictated that it stay its hand. Norms that have been framed by the scholarship and the courts as federalism, in federalism terms. My book showed that framing is not really the correct one. Instead, it was more so partisanship because these norms were quickly discarded when it became politically inconvenient to adhere to them in the decades leading up to the Civil War. So it wasn't true federalism constraints in that way. The book concludes that if we truly understood Congress's power in this area, we would recognize that not only is Congress supreme over the states in many more aspects of election regulation than Congress is given credit for, but it is also a co-equal branch with the Supreme Court in protecting the right to vote from undue encroachment by the states. So judicial review of federal voting rights legislation has to take this into consideration in reviewing whether or not Congress has exceeded the scope of its authority. The only way it can do that is by taking into consideration the full scope of congressional power over elections beyond the 14th and 15th Amendments. So in thinking about this question of the constitutional political structure, my book considers four structural provisions that have not received adequate attention, but supplement Congress's authority. The first is the Guarantee Clause. The second is Section 2 of the 14th Amendment, which most people are not familiar with, allows Congress to reduce a state's delegation in the House if the state abridges or denies the right to vote to its citizens. Also the Elections Clause, which allows Congress to make or alter state regulations that govern the time, places, and manner of federal elections. And finally, Article 1, Section 5's delegation to Congress to judge the elections of its members. Right. So the book discusses how these provisions interacted with corresponding changes to the Constitution of political rights through the Reconstruction Amendments, both of which are integral to understanding the true scope of federal power over elections, as opposed to just focusing on the Reconstruction Amendments. So to give you some sense of the main argument in the book and why it helps to clarify some of the confusion stemming from Shelby County, consider the Elections Clause. So the Elections Clause, as I mentioned, empowers states to choose the time, place, and manner, but is subject to Congress's authority where they can make or alter such regulations. Congress, by virtue of this authority to make or alter, determines the scope of state power because it can displace state regulations at will. Nevertheless, in exercising this authority, Congress still battles against political norms that implicitly favor state regulation. So the Supreme Court has deferred to state sovereignty in this area of elections because Congress's make or alter authority has been used so sparingly. And Congress has in recent decades, really in the last 50 years, relied on its authority under the Reconstruction Amendments to regulate state and federal elections, authority in which federalism concerns do actually play a role. But the Elections Clause is different, right? And federalism is not the reason that Congress has traditionally stayed its hand in using this power. During the antebellum era, Congress rarely invoked the clause in order to nationalize election administration or to limit state power to a particular substantive area, even though it could, right? Instead, Congress just assumed that well-functioning states will fill in most of the blanks with respect to the nuts and bolts of federal elections. Despite being rarely used, however, the Elections Clause had its own unique set of values that place a premium on congressional sovereignty, that it still wasn't about the states, even though Congress did not use this authority regularly. So decisions like Shelby County, which ignore the Elections Clause and narrow the scope of federal legislation to protect state sovereignty, really do mischaracterize the historical and textual relationship between the states and the federal government over the matter of elections, because they apply concerns about state sovereignty writ large, right? It's not particularized. It doesn't matter for the court which provision is at issue. Instead, the historical record really does bear out that Congress has substantial power under the Elections Clause that is unencumbered by federalism concerns. For example, disputes over the scope of federal authority under the Elections Clause are memorialized in the historical record because of the House's authority under Article 1, Section 5 to judge the elections of its members. Historically, Congress's decisions to exercise its power under the Elections Clause and Article 1, Section 5 together have been much more motivated and constrained by partisan considerations than federalism concerns. For example, the 1842 Reapportionment Act, enacted pursuant to the Elections Clause and requiring single-member districts for congressional representatives, was considered blatantly partisan legislation that benefited the Whig Party. But the Democratic-led Congress decided to seat individuals elected in at-large elections in 1844 in violation of this new law, right, requiring single-member districts, because they benefited politically from this decision. It wasn't about deferring to those states that had opted to violate federal law and elect their members at large. But despite the controversy over the 1842 Reapportionment Act and the subsequent election of representatives elected in violation of that act, very few scholars have probed the gold mine that contested congressional elections are with respect to clarifying the scope of federal power over elections. Nor has there been much discussion about how contested elections have also served as a vehicle to vindicate values preserved by constitutional provisions like the Elections Clause, and as the book goes into more detail, the Guarantee Clause. During Reconstruction, it further proves the point about how the Elections Clause operated free of federalism concerns. So the Elections Clause and Article 1, Section 5 became formidable sources of federal authority that Congress used to not only advance its vision of a broad and more inclusive electorate, but also to police the boundaries of the political community of we the voters post-Civil War. So Republican majorities in the House used their authority under Article 1, Section 5 to set aside elections that violated the 14th and 15th Amendments, that exceeded the scope of the state's authority under the Elections Clause, or that violated other provisions of state and federal law. In election disputes, the House did not require the state to hold a new election. Instead, through its Committee on Elections, the House simply resolved the contest based on evidence presented by the two candidates. The House was not waylaid by concerns over the state's authority over elections, or that the federal government was acting in a domain traditionally reserved to the states. Instead, Article 1, Section 5 became a way to protect the formerly enslaved, while both promoting the ideals of the Reconstruction Amendments and also helping the Republican Party politically. Because, of course, a lot of this was driven by partisan concerns and partisan outcomes. The Roberts Court nonetheless insists on interpreting congressional power over elections in a manner that misunderstands the original constitutional structure over elections. It also minimizes the nation's march toward a more inclusive suffrage, and it discounts the changes to this structure by the Civil War amendments. The court's perception that states retain sovereignty over elections that must be protected from federal overreaching is a relic of a history that's grossly misunderstood. After clarifying the historical record, hopefully my book will conclude by arguing that courts must incorporate these non-traditional sources for policing elections and assessing the constitutionality of federal voting rights legislation. So effectively, when we talk about judicial review of modern voting rights legislation, we're talking about an approach in which the court touches on all of these different sources of authority in order to paint a more complete picture of what Congress can do in this space. And this is better than proceeding as if congressional power only comes from one or two clauses, right? The 14th and 15th Amendments are also key to the story that I'm trying to tell, but hopefully that story is that this is not the only way that Congress can influence state and federal elections. From this perspective, Shelby County is not only a cautionary tale about poor legal reasoning, right? It also highlights weaknesses in the court's approach as a general matter. The case reflects that the court's failure to interpret federal authority over elections in the aggregate, based on all of the provisions that give Congress the power to act, has really resulted in an impoverished view of what federal power means in this area. Instead, the court has to properly account for the allocation of authority between the Congress and the states that emerged after the Reconstruction amendments, right? We need a theoretical framework that is centered in 1868, not 1789, right? It has to account for both constitutional rights and constitutional structure and election regulation, and has to get rid of the predominantly rights-focused jurisprudence. Now I'll take questions now. I hope that didn't run too long.
No, that was perfect.
Okay.
So I want to make sure that we leave plenty of time for questions, but
Okay.
maybe I could kick us off with a question of my own. So I just wanted to ask about the project and the kind of normative motivation for it, because throughout your remarks, you invoke history and the true intent. And I wonder, is your project one that you could almost call originalist? It's trying to restore the original understanding of some of these constitutional amendments in a way that would vindicate Congress's role in election infrastructure? Or is there a different normative basis whereby, the book kind of looks to history to show that really Congress is the one that the institution that we should trust to vindicate the rights of disadvantaged racial groups better? So, and if that's the case, then I wonder whether there are normative counter arguments to whether we can trust Congress. So, for example, we have the classic foxes guarding the henhouse kind of issue here. Why should it be the case that if Congress itself is perhaps not representative, that it would be better than states to vindicate some of these rights and values? And then, of course, there's the familiar kind of laboratories of democracy argument that, maybe the states in times when Congress can't be trusted do play a role in vindicating some of those rights and values. And finally, I'll just observe too that, the more that we have Congress kind of in the picture, these statutes that Congress writes will have to be administered by the White House and the president. And there's recent scholarship, of course, of presidential control of elections. And, you have to wonder, especially the increasing power of the presidency, that actually we're setting ourselves up for something kind of more dangerous relative to the status quo, where a highly polarizing partisan president could really take control of elections in a way that we haven't seen before. And that's kind of setting us up for a kind of a worse collision course than we might have had in the past.
Okay. So yes, things might get worse, but things are already like really bad. So, and it's interesting to start there because I do think that whenever you advocate for a change, a course correction of sorts, there's always a possibility that you could realign the incentive structure in a way where it ends up even more disastrous. So let me talk about my preferred outcome, but what I hope to accomplish with the project and why I think that it'll be substantially better than currently where we are, even if there's a risk of, and there's always a risk there, but there's a risk that things might still go left. So my preferred outcome is a constitutional amendment protecting an affirmative right to vote, right? And so I think ideally that is the only way to get to the level of voting rights protection. That's my preference. Barring that from happening, I think that there's a story that one can tell about Congress's role that is a better reflection of how the Constitution approaches the allocation of power between the states and the federal government than the court has appreciated. And that story actually inures to the benefit of the right to vote. Now, because it shifts to more of a political project, does that mean that there's a risk of abuse, a risk that a powerful president will take advantage of the system for his own benefit? Absolutely, right? But I do think that there's still reason to be hopeful. So the first reason to be hopeful is that Congress has been far better on these issues than the states, right? So we have, a region of the country where they have been particularly egregious when it comes to the right to vote. I don't mean to suggest that we're anywhere approaching the post-Reconstruction era where things were really, really bad and you had massive disenfranchisement. But the South does still tend to be worse on voting issues than other regions of the country, although there are certainly exceptions in the North. But generally speaking, I feel more comfortable with Congress exercising more oversight because I do think they've been better on these issues. So that's the first thing. The second thing is that I don't think I'm making an argument that the Constitution doesn't permit. I'm not an originalist. There are parts of the argument that would exceed what one would call the original public understanding of some of these provisions. And I'll give you an example. So Section 2 of the 14th Amendment contains a penalty. There's a very good argument that the penalty is supposed to be exclusive, right? That Congress can reduce a state's delegation in the House if the state abridges or denies the right to vote. The penalty was envisioned as a very exclusive thing, right? So lower courts have held that Section 2 presents a non-justiciable political question. I actually don't disagree with that, because it was sort of envisioned as this very political remedy to broad disenfranchisement. But there's a good textual argument that Section 2 informs the scope of Section 5, right? So I think that that would permit Congress to adopt a broader range of penalties beyond the penalty of reduced representation, whereas an originalist might say that the penalty is exclusive, right? But I think it's completely a completely justified reading of the text. And so I don't think I'm presenting a originalist project. I think I'm presenting more so a historical one. And really, for me, the question is, to what extent does the history inform our understanding of how Congress and the states share this authority? And to what extent does this history disrupt the narrative about federalism? That's probably what I hope readers really take away from, to the extent that the court puts so much weight on this idea of returning back to this baseline norm where states are the primary guarantors of the right to vote. I really want to disrupt that story to the extent that I can show that Reconstruction in particular really altered the roles of the state and federal government with respect to the right to vote. So I have, certain things I hope to achieve through the project. I wouldn't say it's an originalist project, though. It is about history and how history informs our understanding of the roles of the relative governments in this space.
Great. Okay, questions. Raise your, if everyone could just raise their blue hands, I would call on people as they do. William Hubbard. William, I think you're on mute.
There we go. Okay. All right, thanks. So this is a really fascinating discussion, and of course, so timely. Let me ask a couple of I guess questions intended to kind of complicate how this story might fit, and I think they follow quite naturally from Professor No's questions, and maybe they're even just corollaries to it. So one is, would you feel as comfortable making the claims you're making today in the fall of 2020 in the spring of 2017, when both houses of Congress were controlled by the Republican Party? Would that change how you think about not only what is possible for Congress to do, but what might be on the table for what Congress would do? So if it is true that there is an interest in maintaining minority rule through voter suppression, what would your vision for Congress's authority make permissible in that scenario? And another question that came to my mind is, and this is so far outside my own area of expertise, I don't know how these pieces fit together, but it occurred to me. So thinking about Bush versus Gore, that was a case where there was a question of what is up to the state and what is up to the Supreme Court as an organ of the federal government to have the last word with respect to how votes are counted. And with the Supreme Court intervening in some cases and not intervening in some litigations currently underway, you see some commentators saying, "Oh my gosh, it looks like there's at least 4 justices who seem to be on board with the Bush versus Gore view of the world, which is the Supreme Court has the last word vis-a-vis state courts." And this is different from, of course, state legislatures versus the federal legislature. So maybe this is just a non sequitur what I'm asking about. But I just wonder, how do the issues raised or implicated by Bush versus Gore interact with the issues that you raise, if at all?
Okay, great. Okay, so I've been making these arguments since about 2012. So you you got to live with the good and the bad, right? But I do think your question raises an important point. It's something I've tried to keep in mind in writing. I don't want to overstate what is happening historically, right? Like I have tried to be very, very careful about that because I'm also aware of my normative priors, like the world I want to see. So one of the things I'm careful about is, and why the elections clause is useful here is because I am comfortable saying that the elections clause is not really about federalism. I've written on that, I've thought about it. I can't say that about the 14th and 15th Amendments, right? I don't think that's an argument that I could really make in good faith. It's really clear that one of the reasons why there's no affirmative right to vote in the 14th Amendment is because Congress believed that states should still play some role here. Right. So my thesis is that Congress's power is much broader than the court conceives it, not that Congress completely displaces the states with respect to election regulation. So that view of the world actually helps me in a time where Congress has policy preferences that are not my preferences. Right. So the states still have a role here and the states can still counteract some things that Congress does, even if Congress is doing things that I like or don't like. Right. But that's just by virtue. I'm trying to use history in order to illuminate, not to not to paint a view of the world in which Congress acts independent of the state in all things that touches on elections. That's not my goal. With respect to Bush versus Gore, what is up to the state and what is up to the Supreme Court? Bush versus Gore is always really interesting to me because I felt like the Supreme Court was not viewing itself as the Supreme Court. I always perceive of that case as the Supreme Court feeling like it's acting on behalf of the Florida legislature, not in a sense of being partisan, but just in a sense of the Florida Supreme Court feeling like the Florida Supreme Court had really overstepped their authority and intruded too far on the authority that state legislatures have under Article 2 to set the manner of elections. Right, because part of key to Bush versus Gore is this assumption that the state legislature wanted to take advantage of the safe harbor provision, where under federal law, as long as all conflicts or litigation or contests about the slate of electors are resolved by a certain date, 6 days before the electors meet in the states, Congress treats that slate as presumptively valid. So I don't necessarily think Bush versus Gore is a case about the Supreme Court asserting its own dominance. I think it's a case about the Supreme Court stepping in to view what it conceived of the Florida Supreme Court is overstepping the boundaries and intruding too far on the state legislature's power under Article 2. So to me, it's a bit of a different situation. I don't necessarily think that the way I am conceiving of federal power here implicates the same issues. Even though this issue, we're seeing a lot of chatter around it this election cycle because of the independent state legislature doctrine, which came up in the context of the Pennsylvania litigation, right? The question of whether or not the state Supreme Court can extend the deadline for receipt of absentee ballots contrary to state law, right? But they said they were vindicating the right to vote. And that too raises a similar Bush versus Gore issue about whether or not the state legislature is the only organ in the state that can weigh in on the presidential election in that way. So my book, it does have some implications for presidential elections. So I talk a lot about the 12th Amendment and how that altered our understanding of what republicanism requires. But not really this issue of what do you do when you have a conflict between really state legislature and the state courts and the federal government have to weigh in, or whether or not the extent to which federal courts can weigh in on interpretations of state law. So that's not really directly related, but I see how those issues come to mind, especially given the election cycle that we're living in.
Michael Ortega.
Hi, Professor.
Hi.
So in listening to your talk, I've been thinking about two things.
Okay.
One, assume that like Congress buys your argument about increased federal power in elections. That power seems limited to federal elections exclusively. And then I've been thinking about that in conjunction with the fact that regardless of the kinds of voting laws or election laws that Congress passes, states will still largely be responsible for the bulk of election administration. And so my question is how those two things interact. So if Congress passes the For the People Act and says every state has to have automatic voter registration, then is it just up to Congress to figure out some sort of implementation mechanism for the states and we get into a cooperative federalism type space? If Congress decides to wield its federal power to, as I think Professor Hubbard was suggesting, to level down voter protections instead of leveling up, how does that interact with states who want to take a different path? Like, I think your argument is right in the sense that these clauses are not talking about federalism, but the very nature of how elections are run implicate these kind of federalist fights that we have about the value of diversity across states and the ability to administer federal programs at the state level. And so I'm wondering if you could talk a little bit more about that.
Absolutely. Thank you for a great question. I do think that, so to say that congressional power is not constrained by federalism in this space to the extent that we assume that it is, does not mean that Congress itself should not be politically concerned about federalism. Right? Because one of the points I make in the book is that during the 19th century, one of the reasons why Congress did not legislate extensively pursuant to the Elections Clause is because they did sort of talk about things in terms of federalism until it became politically unpalatable to do so. Right? So it's not that, so I guess I'm drawing a distinction between federalism that the Constitution requires and political federalism. Right? So I still think that to some extent, even if Congress says, hey, we do have all of this power, they'll still be constrained by normal politics. And that doesn't bother me, right? So generally the things that we argue about and the things that we care about with respect to voting in elections will not be sort of the everyday pedestrian election administration that the states engage in. I think that the state should continue to have primary oversight over election administration. And I think that even if Congress acknowledges that it has all of this authority, that will continue to be the case. But importantly, I think one of the reasons that the book is advocating for a more comprehensive view of congressional power is because I do want to make it clear that this is not necessarily limited to federal elections. We don't talk a lot about the guarantee clause, but during Reconstruction, the guarantee clause was a way for Congress to really get at state political systems, both state and federal, right? So it doesn't have to just be limited to federal elections, but if you just focus on the elections clause, for example, in the absence of intentional racial discrimination, you might draw that conclusion. So hence my point about thinking about congressional power in the aggregate so that we don't have those gaps and we can really think about what Congress can do. But again, I would caution that I'm not advocating for complete displacement of the states. And I expect there still to be some political constraints on the ability of Congress to legislate expansively. During times when Congress decides to dial down voting rights, for example, states can still pass laws that are more protective of the right to vote as they often do. I'm not trying to change that.
Brandon.
Good afternoon. Could you imagine a way to incentivize states in order to encourage the universal suffrage and to encourage minorities to vote, even though they run the risk of losing power during the election? Certain parties, whoever is in control of kind of wanting to suppress the vote.
I do think, and this goes back to the prior question by Michael about what do you do when states are still in control of the election administration? If Congress legislates on the federal side, right? Let's say Congress, if you look at HR 1, right? HR 1 applies to federal elections and it will require automatic voter registration for federal elections. It's very hard to believe that states won't feel compelled to do that for state elections as well, because the alternative is that they have to run parallel voter registration systems, which is very, very expensive. Right. So to some extent, by legislating on the federal side and just focusing on federal elections, you incentivize states to adopt a similar structure for state elections. There are states that will probably still resist this. But generally speaking, I think that you'll see most states capitulate and decide to run a unitary system in order to avoid the expense.
Okay, so we also have a question in our chat. Robert asks, should Congress use its power under the Elections Clause to constrain gerrymandering?
Yes. But it's one of the, it goes to sort of this point about partisanship, and this might actually be one of the downsides of the book. So it's one thing to say that Congress is choosing whether or not to act because of partisan considerations, even if they're framed in federalism terms. But those same partisan considerations operate both ways, right? Congress can choose to discard the partisan reasons. Discard the sort of federalism veneer because the politics have changed. But because this is partisanship, this will also stymie needed reform, particularly in the context of partisan gerrymandering. Congress arguably can address some of this, right? HR 1 tries to address some of this by requiring independent commissions for congressional districts. So it does try to address it to some extent, but the political winds have to be such in order for that type of legislation to have some likelihood of becoming law. So the partisanship actually cuts in both directions. Yes, honey? Sure.
Wait, I can open myself.
Okay, bye.
Great. Other questions? Right. I think Professor Huck has a question.
Hi, Fernita. I had two questions. One is whether you think or whether you think there are limits upon Congress's power under the Elections Clause, and where those limits come from. I have in mind variants, I think, on Professor Hubbard's question, such as what if Congress were to employ its Elections Clause power to require some sort of national ID scheme. What if it were to directly impose a highly gerrymandered map for House districts, would post the Supreme Court's conclusion that there's no cause of action in federal court to challenge such partisan gerrymanders? Where would the constraints upon Congress acting under this power come from? The second, I think, it goes to what I believe is the kind of foundational, or maybe a foundational presupposition or assumption in the core argument of the book. I think that what I hear you saying is that, look, if we let Congress regulate elections, that will yield more inclusively democratic outcomes than the current arrangement, where the courts have, in particular the federal court and the Supreme Court, have authority. So the comparison there, I think, is between the preferences of the courts as opposed to the preferences of the democratic process at the national level. But of course, the preferences of the courts are themselves a staggered and somewhat distorted reflection of the preferences of those who appoint the courts, the Senate and the presidency. And so one way of taking your claim is that, look, if we allow the House plus the Senate plus the president acting through bicameralism and presentment to calibrate election law, we'll have more inclusive outcomes than if we lean more heavily upon the Senate plus the president as their preferences are expressed through the judiciary. And I wonder whether you could say a little bit more about that comparison and why we should think that the preferences of the first constellation of actors are going to be systematically more inclusive than the preferences of the second group of actors.
Okay. I'm gonna start with the second question first, so I think that's more difficult. Oh, wow. So I guess I never questioned whether or not that was an assumption, but I feel like you might be right about that I'm assuming that Congress is better. But then another part of me thinks about this and I'm just like, do they have to be in competition? You know, when we think about whether or not the courts or Congress will yield more democratic outcomes, it makes me realize the extent to which the book is reactionary, right? So to some extent, the courts have already abdicated their responsibility here, even if my initial preference was for courts to resolve a lot of these issues, right? So in some ways, the book is saying like, to the extent that the courts have abdicated their responsibility, and maybe I haven't said this explicitly in the book, and I need to be more clear about that, but to the extent that the courts have abdicated their responsibility and they're making it hard for Congress to do anything about this, Congress actually has this power, right? I don't necessarily think that I'm assuming Congress is better, right? But I'm trying to provide an avenue given the terms of the debate as the Supreme Court has set it. I actually think that courts might be better at this. I am a fan of the Warren Court here, but it seems like that avenue is closed. So I don't know if I'm assuming that Congress will result in more democratic outcomes than the courts. It's more so that since the courts have kind of, decided they don't want any part of this, we can get democratic outcomes through Congress. So I don't necessarily see it as a comparison or a competition. With respect to the first question, there are some limits on the elections clause that strike me as probably right. So the Supreme Court in a case called U.S. Term Limits versus Thornton said that the power under the clause, time, places, and manner are limited to procedural rather than substantive determinations. So I think that I'm still okay with that, although with the caveat that sometimes it's really hard to draw that line. And I think your examples are cases in point, right? Like a national ID, is that a voter qualification standard or is that a manner regulation? And the legal scholarship has not been entirely clear about that. To the extent that it is a voter qualification standard, Congress could not impose a national ID through the elections clause. But if you see it as a manner regulation, right, a way in which somebody verifies that they meet the age, residency, and citizenship requirements, then perhaps it's just a manner regulation. So in some ways, I don't know if it's enough to say that the procedural versus substantive distinction works in the context of the elections clause, as opposed to just shifting the argument downstream. So there are and of course, Congress will still be constrained by other constitutional provisions that will prevent it from passing manner regulations that, for example, are discriminatory or, whatever. Like my comprehensive view means that we're really reading it comprehensively. But generally speaking, Congress's power under the elections clause, I do view it as the court has as plenary. But I would still argue that restriction is there. Like I'm not challenging that in the book, although I have in prior work challenged whether or not it's a meaningful restriction.
Yeah, if there's not a student question, can I follow up with one question, Jennifer?
Please, yeah.
Fernita, one of the most important limitations upon the states is obviously the Equal Protection Clause, which was originally contained in the 14th Amendment and therefore applied directly to the states rather than to the federal government. And it was only applied to the federal government in Bolling v. Sharp, which was the case about DC school segregation in 1954. Some academics have pointed out, and I'm thinking here of Richard Primus's article on Bolling from the mid-2000s in particular, that both as a matter of practice and as a matter of theory, it might be that the equal protection limitation applies differently to the states than to the federal government, right? So Richard's argument, Professor Primus's argument, is that as a matter of practice, the federal government has never been subject to the same level of equal protection enforcement as the states. And maybe there's a good reason for that. Maybe the federal government ought to get more leeway, either when it comes to discriminatory subordinating actions, or when it comes to the employment of affirmative action in its ilk, right? And I wonder whether that's something that you'd care to speak to, right? Should the equal protection and I mean, I guess you could do the same thing with due process, or at least it's some of its entailments under the 14th Amendment. But I think equal protection might be a more interesting lens to think about that. Right? Should it apply differently?
So with the caveat that I have not read that article and need to read it. It sounds fascinating. I do think that makes intuitive sense. And so, if you think about the context of equal protection, and to me, this really comes up when you have the court reviewing the legislative record underlying something passed under the 14th and even the 15th Amendments, right? So it seems like the argument that equal protection applies differently to the federal government than it does to the states could be especially relevant in the context of trying to figure out questions of discriminatory intent. So let me ask one clarifying question. When we say that equal protection applies differently, are we talking about the remedies that Congress can adopt? Or are we talking about the level of discrimination at the state level that's required in order for Congress to adopt? Does that make sense?
Yeah, I think it could be either. I think it could. You could either think that Congress is subject to a weaker level of scrutiny than the states, maybe because the historical circumstances of equal protection's adoption imply a particular distrust of localism, or it might be that there are substantive limits upon the remedial authority of the federal courts when it comes to the federal government, but not when it comes to the states. And an example of the latter would be the 2017 or 18 decision in, I think the name of the case is Santana Morales, which is a case invalidating a provision in immigration law for violating the gender strand of equal protection, invalidating it in such a way as to level down, to eliminate immigration benefits rather than to provide a remedy to the actual plaintiffs in the case, on the ground that the court doesn't have the power to admit individuals to the country. So that's an example where like you say, a remedy is denied because of a distinctive federal legislative power in a way that may not, I'm not quite sure what the analogy would be at the state level. I think that the outcome at the state level might be different.
I mean, personally, I would like that principle that the federal government is different to apply to remedies, as opposed to, because to me, the clearest example is that when the federal government itself is trying to adopt an affirmative action plan, right? And so based off of your description, it seems like saying that equal protection applies differently might allow them to do that in a way that's not true of the states. But I would like to see it manifest on the remedy side, right? Congress also has greater ability to remedy equal protection violations because of, the concerns about possibly misusing the concern, I'll put it this way, the concerns about localism and the need for a uniform solution might apply more strongly that the court is willing to give them room, right? So definitely need to take a look at the article, but my sense is that a parallel could be drawn here where the federal government is free of certain equal protection constraints in a way that wouldn't be true of the states.
So if there are no other student questions, I'd also like to ask another question since we have the privilege of having you here. So because the topic of state election administration has come up, I wanted to ask, in addition to thinking about Congress's authority to regulate, I wonder if you had thoughts about the best ways of how Congress should regulate, and in particular, in thinking about the kind of institutions to which it should delegate power to administer its statutes. So for example, I'm thinking of, the Voting Rights Act administered by DOJ and has a lot of problems because it's partisan. And of course, it's also, the Federal Election Campaign Act administered by FEC, completely deadlocked, not taking action on important, significant questions in the statute, the Help America Vote Act, administered by, agencies that are similarly deadlocked. And so anyway, I just wondered if you thought about the kind of institutions to which you'd want to delegate power through these statutes. Do you want to design your own? Are there existing institutions that you think, should be the target of these statutes?
I have no idea. And let me justify my no idea though. Like, I actually think it's good that I don't have any idea. So I think that I have been too seduced by like the Voting Rights Act and how successful it was, because it did have problems. And I think the problems were the fact that jurisdictions were not bailed in when they needed to be bailed in. Jurisdictions were not bailed out when they needed to be bailed out. The problems were also, as you mentioned, the DOJ. The problems were that, the coverage formula wasn't updated when it in fact needed to be updated, right? So it wasn't as if the Chief Justice had pointed to a problem that didn't exist. It actually did need to be updated. But I think because of its like overall success, in my mind, I often point to that as like my baseline. Like, okay, how can we, sort of replicate the Voting Rights Act? But the reality is that we are far past that. Guy Charles actually has some really interesting work on how the sort of race-based coalition that advocated for these types of remedies has fallen apart in the last 50 years. And we really need to move towards something that's a more race-neutral statutory regime and thinking through how to address voting rights problems. And we also need to have more movement at the state level. So any solution, even though I just feel like I'm writing about a part of it, because any solution cannot be primarily federal. It has to be a partnership between the federal government, between state actors, between private actors, right? I feel like the voting rights bar plays a huge role in protecting the right to vote in a way that should, be a part of any institutional design. I don't think that it should be something like the FEC or the Election Assistance Commission or any of those entities which have proven to be completely flawed and ineffectual. So that's actually a really tough question. I've thought about it from time to time, but I think part of my problem is that I have venerated the Voting Rights Act, and I'm trying to get away from that because it was flawed. And not only was it flawed, I think that the time has passed for that type of race conscious measure. Because even if you look at HR 4, which is the new coverage formula that is in front of Congress right now, it would only cover like 4 states, right? This is kind of the best that they can do in light of the Shelby County decision. And so that shows that we really have to start thinking about other alternatives. I do think, as I mentioned, an affirmative right to vote in the Constitution would go a long way. It's just unlikely to happen. But I can't think of a good replacement for that. Not if I hope to sort of get where I want to get with respect to something approaching universal suffrage.
All right, on that note, thank you so much, Professor Tolson, for your time. Again, it's such a timely topic, such an important one, such important work. So please join me in thanking Professor Tolson, and we will look forward to having you back in the spring.
Yes, looking forward to it. Sign up for election law, kids.